I agree. And in fact, I've successfully defended on my last homicide that I tried, keeping rap lyrics out of court. And the reason why this was a case where my client had created a rap video, and it was kind of a drill type video. And when he did this video, he's talking about, how he would respond to guns on the street. What is that? What kind of evidence is that? It's bad character evidence. It's called 404. You cannot offer bad character evidence of the accused in a criminal trial first. So to the extent that it is bad character evidence, you can't do it. And that's how I was successful in keeping that out. And so when you have a statement of a party opponent, you got the state, you got Mr. Williams. So Mr. Williams is the party opponent. So if the state has a statement of the party opponent, they can use that against him if it's relevant and material. So it has to have some relationship. It can't just be that you can use any statement from anybody at any time. The judge read in the jury selection Thug's own words.
Hey, this is that slime shit. Hey, YSL shit. Hey, killing 12 shit. Hey, fuck a jail shit. Hey, cooking white brick.
But he's reading this stuff, and I don't know if they tried to litigate that ahead of time, but the actual songs themselves, they were using, the prosecutor was using in the indictment itself as an act in furtherance of their conspiracy. So one of the things, when you're doing jury selection, they read you the charges. And, there's like, 60 or 70 counts in that indictment. That should have been litigated ahead of time. And maybe it was. I don't know if it was or not, but I would have filed a motion saying, look, they put this in their complaint. They put this in one of their acts in furtherance of the conspiracy. But we think it's so prejudicial. I mean, fuck the judge. That was one of the lines. Fuck the judge. How is that statement a statement in furtherance of the conspiracy? They're talking about the legal system. They're talking, to me, it's just so much more prejudicial than probative. And some of the other things that they talked about when he actually made those statements in court. When you have their attention and you're spitting those words out, they're hard to ignore, right? They're absolutely hard to ignore. I'm a defense lawyer, and I'm probably one of the few lawyers out there who've actually litigated this issue. And I argue hard to keep those lyrics out because they are so prejudicial. And it is art. And if it's not talking about a specific crime, all it is what? Propensity evidence. Trying to show that my client acted in conforming with some other prior behavior. You can't do that. A prosecutor can't do that. If you talk about something else, like some other act the person does, and it has nothing to do with the case, the only purpose for that act, whether it's a song or whether it's an act that he did, it's just to show that he's done it before, so he's going to do it again. And that's just propensity evidence, and it's highly prejudicial, more prejudicial than probative, and that's kind of the standard.